And now to judicial matters. The Court of Appeal, Abuja Division, on Friday struck out an appeal filed by the convicted leader of the Indigenous People of Biafra, Nnamdi Kanu. In the appeal, the IPOB leader challenged what he described as the violations of his fundamental rights by the Director General of the Department of State Services, DSS, and the Attorney General of the Federation. A three-member panel of the appellate court held that the appeal lacked merit and had become academic following Kanu's conviction and life imprisonment sentence by the Federal High Court in Abuja on November 20th. Joining us now on the news to discuss this further is a legal practitioner, Tohwo Oseruvwoja, and he joins me live from England. Tohwo, it's good to have you join me on the news. Let's just get right into it, shall we? Can you explain why the court appeal struck out Nnamdi Kanu's appeal regarding alleged violations of his fundamental rights? They claim it's academic. Is it academic?
Judy, can you hear me?
Loud and clear. There you go. Go ahead.
It's okay. If you look at the right Nnamdi Kanu was claiming for, if you look at it, looking at what Honorable Justice Tohwo delivered on 30th of July, either 30th of July or 3rd of July, you look at it from the perception of rights to human dignity, which is under Section 34 of the Constitution. You look about rights to better healthcare, which can be linked to rights to life under Section 33 of the Constitution. Then the last one is the freedom of thought, which is Section 39 of the Constitution. Then if what, according to the Court of Appeal, where can an issue become an academic exercise? It becomes an academic exercise by the pronouncement of the Supreme Court when the issue raised are basically theoretical and of no value when judgment is being delivered in favor, even in favor of the applicant. So now, I think my own view on this issue, let's get one thing clear. A defendant or a convict is entitled to remedy when his or her right is infringed. And that does not stop the criminal liability the person is being charged for or being convicted for. And I believe that, yes, he talks about right to human dignity has been violated. I think the court would have, for me, such a thing, the court would have made a pronouncement whether or not his right was violated based on the evidence before the court. Then the one of better health care, that one is something the court would have also made a pronouncement on if the merit was there. So the court would not have maybe look at the criminal conviction of Nnamdi Kanu in determining whether this issue is an academic exercise, because issue of rights does not the issue of right violation is not at the point when judgment is delivered. It's at the point the person alleged that the right, his or her right has been violated. So I believe, just we as lawyers, ours is to make our opinion, but whatever the judges says is what the law is. But that is why we also have the hierarchy level of the court, whereby you go to the Supreme Court. But for a court to say that an infringement of fundamental rights is an academic exercise, I think is not something that the Nigerian jurisprudence recognize, in my opinion, personal opinion.
All right, so I mean, given the reasoning that the courts has deemed the cases as academic, what then will now be the legal options that will be available to Kanu, and will it affect the legal options available to him in any way, shape, or form?
No, not at all. It's not going to affect any legal option available to him. That is why the council, that is why we have the Supreme Court. So two things would have happened. Yes, it's either the court would have found him or found that his right was violated or not. If his right was violated, then the other thing that will now come to bear, just like what the court pronounced, is whether it should be transferred from the DSS custody to the correctional facility. So, but that has been overtaken because currently it's in the correctional facility. So it's the remedy that will be looked at. But another thing again is that if he has not proven that his right has been violated, obviously the court wouldn't have said that, well, it's an academic exercise. The court would have looked at the merit of the case. So options available for Nnamdi Kanu now is for him to approach the Supreme Court, and I think maybe he's a man. I won't say grammatical error, but I think is the wordings of the court towards dismissing the case. And I believe the Supreme Court would have made, will look at it and see if there is merit in his fundamental right infringement or not. So that is the remedy available for him, for his counsels or his counsel to take now.
Right. What about implications? What implications then does this, dismissal have for Kanu's claims about restricted access to lawyers, doctors, and religious practice while in DSS custody?
That is the implication now is that, because another thing again is that we should also look at what is before the court. What are the evidence before the court? We should not be overwhelmed by what is being reported at the media. So the implication now is the fact that, because the court is saying it's an academic exercise, so the court, for me, in my own opinion, I think the court did not look at which is the appeal courts now. Because if you look at the judgment of Honorable Justice Tohwo of the Federal High Court, you see that he said that Nnamdi Kanu could not prove the infringement right of what he is claiming for. If he was treated inhumanly, if he was deprived of good health care, if he was deprived of freedom of thought, he could not prove that. Yes, that is why they approached the Supreme Court. So looking at the pronouncement, the Court of Appeal, looking at the pronouncement of the Court of Appeal, you discover that they didn't look at the merits of the case. They only look at the technicality of the fact and the impute of an idea of academic exercise. So the implication is that as it is now, Nnamdi's right is not violated based on this current pronouncement of the High Court and the Court of Appeal. So it all depends on what the Supreme Court, if they will approach the Supreme Court. But on the other level of it, it also make it more of, it gives the notion of a political intonation rather than policy and law play. Because if anybody gets to hear this kind of pronouncement coming out, the mindset of the average Nigerians will not be that, oh, justice is served. It will be, oh, it's being witch hunted, which is a quite different perspective. Then the other implication again is that it gives the judiciary ought to be an exchequer or a checker of the SSCs of the executive, which can be carried out through the law enforcement agency. So if such pronouncements are coming in this regard, you know what the law agencies will do. So they will say, okay, well, we can do this at this point in time, we can rush the process and it will become an academic exercise. It's not a good one per se, right. Looking at the pronouncement and looking at the way the media is going about how the judgment or the reason behind the dismissal.
Right. And how does the appellate court's decision interact with the Federal High Court's earlier ruling and also his current imprisonment at Sokoto Correctional Center?
Yeah, that is my bone of contention. That's my bone of contention and my fear, because the fundamental right case has nothing to do with his conviction. These are two distinct issues here. We are talking about a criminal liability and we are talking about a civil wrong here. Just like I told you earlier on that, yes, a person can be convicted for murder, but also be entitled to remedy a human rights violation. And when a person's right is violated, does not automatically transmit to, oh, because my right was violated, the criminal action before me should be stopped. So for the court to have imputed that in one way or the other, though I understand the issue of inhuman treatment. Now the question would be, or I understand the issue of inhuman treatment, most times when that issue comes up under criminal matter, it goes to the issue of his statement taking and every other process that that is presumed to have been done when he's in custody. It does not stop the court to pronounce yes or no, this thing has been avoided. So, but another thing we should look at is our policy guided is our judiciary. It should be a concern. Our policy guided. We're not talking about politics now, because where policy ought to strive and politics takes place, that is where anarchy is let loose. So we should be looking at our policy guided is our judiciary when it comes to issue of public interest issues like this. So for me, it's a very big one. And I think let's see what the Supreme Court is going to say. I'm not saying that his right was violated or not, or his right was not violated, but the reason behind the dismissal of the case is what is a concern for me as a lawyer.
I mean, Tohwo, you are not just a lawyer, you're also my learned friend, but also you're a scholar as well who's teaching others, and you are quite informed and educated in this field. So I do have to ask you, when you look through the entire legal team as well as the entire process with Kanu and his defense or the prosecution side, were there any procedural or legal missteps that by Kanu's legal team that might have influenced the court's the Court of Appeal or even otherwise?
Well, if you look at looking at the trial altogether, I think Nnamdi Kanu as a person made a fundamental error when he disengaged his lawyers. That is one. And if you also look at it, the court in its infinite wisdom gave him all the ample opportunity for him to enter his defense. And for you to say right or fair hearing is because I believe it may be one of the ground, and I've heard some of his lawyers speak, particularly if you see the senior advocates among them, they are a bit calm because they know the process and they know the procedures. So I think it's basically the media narrative aspect of how they manage the information they dish out. And another thing again is for the part of the prosecution, how they manage the information they dip out. I have no issue with the criminal process of Nnamdi Kanu's case. I have no issue as a matter of fact with that. But I also have issues, the procedural issues when it comes to his fundamental right case. That is where I have issues. And I'll tell you as a matter of fact that I've been privileged to practice in Nigeria, and I've been privileged to be a key observer of judicial processes in the UK, which is part of where we borrow some of our laws from, technically, our procedures from. You discover that the fundamental right issues, the way it was being handled, both by the councils and some of the pronouncement coming from the court, is a bit disturbing. And it's something young lawyers, particularly we young lawyers, should learn from when managing cases of this nature.
Tohwo, I just said we young lawyers. I hope you were not referring to yourself.
No, I am also. I am.
Tohwo, many thanks. We appreciate
At least I'm not a senior advocate, so that makes me a young lawyer.
Look, so Tohwo, many thanks. We appreciate you for coming on.